All right, so we are live now. Happy Friday, everyone, and welcome to the consultation. My name is Christina Jimenez.
I am James Palin.
And I'm Julie Prentice.
And we are all attorneys over at the Jimenez Law Firm. Thank the Lord, Mr. Floyd is on vacation today, so he will not be joining us. And so today or every Friday, we come together at noon and we discuss different fact patterns, legal fact patterns. I tell everybody at the beginning, middle, and end that this is not to be construed as legal advice. And so what you're going to find out is, as we're going through and we're talking about these scenarios, is the slightest little nuance in a case could potentially change our opinion on what could happen in that particular case. So it's good for you all to be listening to kind of get ideas of how most judges or some judges may rule. But what I would like for you all to do is to take the information that you receive here and go and find you a lawyer that you're comfortable with, preferably somebody that's in your county that practices in front of your judge, because that attorney is going to be able to guide you as it pertains to your particular facts. So very, very important that this is just informational. Don't construe it as actual legal advice. And so with that, so Keon always has a little reminder here that you guys, if you could please follow us on social media. We have Twitter, we have LinkedIn, we have Instagram, we have TikTok, Facebook, we have every platform imaginable. If you all could go and you could follow us, we would greatly appreciate it. We also have podcasts, we have a YouTube channel. And so obviously the more awareness and information that we're able to share, the better it's going to be in the legal community and for anybody who's having to go through these types of scenarios. So with that being said, let's start with question number 1. James, you want to read that one?
Sure. Will my son have a warrant for his arrest? Okay. My son got picked up for hitting his sister. He has a court date, but refused to go. I cannot physically put him in the car and make him. I've tried everything. He just doesn't care. What can I do? What do you think, Julie?
Well, if he missed a court date, then he's probably going to get picked up. Yeah. It puts a warrant out for his arrest, and sounds like he's probably a juvenile. If he's an adult, then there definitely will be. Juvenile system works a little different, but still basic principle. If you miss court, you're going to be in trouble. Yeah. So as the parent, what can you do? I mean, you need to try to make him go. If I were you, I would be in contact with the court and they can help you with that if need be.
So, and I haven't done a juvenile case in a while. And I know, James, you've been, you've worked on a few, and we have a couple that we're dealing with, but I think you and Floyd and Julie have all kind of taken lead. So I remember, and you guys correct me if I'm wrong, but when it's a juvenile, they typically have what they call a detention hearing within, is it 5 days or 10 days?
10 days.
10 days. And then when you go to that detention hearing, typically, I guess what happens at that point is the kids are already being detained, and it's more of a, should we be able to release them to the parent? I don't know that we've ever had a case where like a kid just refused to go.
Right. And I think that goes into our question, like, what can I do? How do you incentivize a kid who doesn't seem to care? And Floyd and I, we talk about that a lot. And even CJ, you and I have talked about, those come to Jesus conversations. Sometimes you have to have with the younger ones, because they don't understand the gravity of the decisions that they're making and the rippling effects and consequences once, hey, look, you're out of juvie now, or you're going to be in juvie and you're not going to be released, and you're going to be in here with bigger kids and bigger bullies, and it's going to set you on a detrimental path.
Right. Yeah, we've had a couple of those conversations with clients, James and I. They've been fun.
Yeah, I mean, they always, they seem to get the picture. Once we bring in the big guns, they usually seem to get the picture.
But Don't they typically have like a probation officer? And I hate to call them a probation officer because they're not technically on probation, but there's typically probation juvenile officers that are appointed to these kiddos. And so, I used to, whenever I did this, I knew kind of the head of the facility out there. And I would just call him and he'd say, oh, well, let me have this officer go and talk to the kid or go pick the kid up. Right. And so I would encourage mom to make those calls, because what you don't want to happen is you don't want this officer to have this perception that mom's not complying and mom's like indifferent and basically helping him evade. And then now mom has bigger pictures, especially when kiddo gets picked up and then you have the detention center, you have him in the detention center, and then you have the detention hearing. And one of the elements is that you have the ability to produce this child back in court, right? And if mom can't show that to the court, then her son's going to be stuck in detention until such time as you can get a final trial, a jury trial, or a final disposition hearing, and then they sentence him and the case is wrapped up. But that's just going to be really sad for the kiddo. I don't know. I have a teenager at home, and so I feel for this woman. I really I feel for you. But thankfully we're not having these types of issues. It's tough. And you're right. You can't physically do it, because then, what happens if you get picked up on criminal charges for some sort of abuse or endangerment or some crap like that. So call the probation officer. Let's see. And he probably does have a warrant for his arrest if he didn't show up to court. So let's cooperate. Yeah.
Yep.
All right. Next question. Let's go with numero 4. Julie, you want to read that one?
Yeah. Do I have a right to know who is babysitting my daughter? My ex-husband is finally taking my daughter for his 1 month in summer. He also told me he wouldn't be able to watch her one day while he is at work when I asked him who would be taking care of our daughter. He told me not to worry about it and that he didn't have to tell me who it is. Can he do this?
I like the inflection, Julie.
Good character. I like it. But it's going to depend on that order. Sounds like he's read it and you've read it, so you understand the possession. But whether or not he discloses that information to you is what sounds like discretionary. If it's in the order that he has to provide that information, that you all came to an agreement that, hey, this is going to be the terms, visitation, you're gonna have to let me know which daycare, which babysitter, how old they are, how qualified they are. Those are important provisions. And, we don't want to understate that. However, if it's not in there, it's not in there. And he's going to have the ability to provide childcare as he sees fit. So double check the order.
Yeah. And I would say that most judges are not going to incorporate those provisions. We can ask for it. And I think if both parents agree, in a lot of cases, both parents want that to be incorporated because there's clearly a lack of trust. But in cases where like dad doesn't want to have to share that information and mom is asking for it, I haven't had a whole lot of success, because if the dad is safe and he's appropriate and there's no safety concerns, the judge is not going to allow mom to micromanage him. Right. And so, and I understand for sure that there's definitely some parents, mom or dad, that maybe the other parent has safety concerns or trust issues with them or whatever. But if you separate from someone, and that's a hard realization for people to have, is if you make this decision to leave, or if they leave you and you guys share a kid together, whatever they want to do, they get to do. And whatever you want to do, you get to do. And you just have to have faith that neither one of you guys are going to put this kiddo in a dangerous situation. But it seems to me like maybe they're just trying to control, maybe. I don't know. But, and the other thing is that I will tell people is, if you want the other party to do something, then you do it. And hopefully there'll be some good faith and there'll be some reciprocation, right? So, hey, just so you know, for spring break, I'm going to leave baby with this person. Here's the address. Here's her, CV, whatever it is that you want to give them. When you have her for the summer, would you mind doing the same thing? Now, of course, he could say, F you, I'm not doing any of that. It's none of your business. Or hopefully he would say, absolutely. Thank you for sharing this with me. Here's the info. Have a little bit of grace, have a little bit of kindness. It goes a very, very long way.
Yeah.
So,
Respect.
But you're right, James. It's probably not in the order, and Dad's gonna be able to do what he wants to do. So, I don't know. I don't know that a judge would care if she asked this question and he, like, let's say she went back later to try to get the provision in. I don't know that a judge gets upset with him for not sharing the information. I don't think it has any impact unless the kiddo's in danger. So, anything else on that?
Well, just to, I guess, push back against my own point, in cases of emergency, and not that this person is negligent, but hey, something happened and I'm having a hard time getting a hold of Dad, and this has happened to the kiddo. He or she who is, taking care of the kid should be, in a perfect world, be able to contact an additional emergency contact. So it's I think it can be looked at as a parenting concern. Hey, I'm leaving multiple contacts. They can call you, they can call me if something goes on, and not so much as the micromanaging, but I'm sensing a little bit of that there too. Mm-hmm. Even in a practical sense, I think this still makes sense that, hey, let me know who's watching the kid. Just if nothing else, he bumped his head on something, can't call you. He or she could call me.
Well, or Lord forbid something happens to Dad and he's in some sort of an accident or something, and then Mom doesn't know where the kiddo is, and then we have all sorts of crazy issues. I always encourage our clients to not be assholes, like to just don't fight fights that don't need to be fought, because you're going to spend a lot of money on attorney's fees fighting those fights, and it's not going to be good for your kid, most importantly, right? And so in a case like this, just share the info. It's not going to hurt anyone. She doesn't have the right, because Dad's going to have his summer visitation. He has temporary and exclusive, not use, that's property. He's going to have temporary possession of that kiddo for the entire summer. And Mom can't take the kid, even if she knows where the baby is. She's not gonna be able to take him. And if she does, she's going to be held in contempt of court. So I would say just share it. And I would encourage Mom to share her info, but Dad doesn't have to. He's not going to get in trouble if he doesn't. It's just, I don't know. It's just silliness when parents fight over stuff like this. So, all right, next question. Let's go 7. What's number, who wants to read?
I'll read.
Go for it.
I missed my divorce hearing. A default judgment was the result. What should I file? I missed my divorce hearing, which resulted in a default judgment. The man is a seasoned con artist, okay? The hearing was set when my child needed hospital administration. My ex knew I wouldn't be able to focus on the court. What should I file now? CJ, what do you think?
So it depends. That's the typical lawyer's answer. So it depends on when the default judgment took place. So if a default judgment is taken against you, you have 30 days after the judge signs the order to file a motion to set aside default judgment or a motion for new trial. And basically in these motions, you would allege that there was a certain reason why you didn't show up, your kiddo was in the hospital, etc. And you could request that the court set aside that default judgment. Now, I will say it gets super complicated because It depends on if it was a no answer default judgment, if it was just you had notice of the hearing and you failed to appear. There's a lot of there's technicalities associated with all of that. And so you're going to want to make sure that whatever lawyer you hire, they know their stuff, because if you don't allege it properly, you could potentially waive your argument, and you obviously don't want that to happen. And so, I would say no answer default judgments. And basically, I guess, let me just kind of back up. So anytime you have a lawsuit, what typically will happen is there's going to be a petition that's filed, and then you're going to get served with that petition. Okay. And the process server typically will come over and hand you that paperwork. You need to read the paperwork. Don't just take it and throw it on the counter and forget about it. Read the freaking paperwork. And in that paperwork, it is going to tell you that if you do not file an answer on the Monday by 10 a.m. following 20 days of service, that a default judgment can be taken against you. Okay. And what that means is that the other side can just show up to the judge, to the court, and say, hey, judge, I served her. She didn't file an answer, and now here's everything that I want. And the judge will say, okay, you got it. Right, here you go. And those are a little bit more, I feel like judges are less inclined to have sympathy whenever you just, and I'll just say I had a case like that. And my lady was a very smart lady. I think she had a doctorate, and she just kind of blew off the paperwork, didn't file an answer. Thank the Lord, we were able to get it set aside, but the judge was kind of, just not very pleased with her, because she should have known better, right? So read your freaking paperwork. If there's a hearing scheduled and for whatever reason you can't be there, you better make damn sure that you have a lawyer that will show up on your behalf, that will file a continuance, or you got to figure out a way to get there, because otherwise you're in this situation, and it's difficult and expensive to set those things aside. And if you're unsuccessful, then whatever he got, that's it. He's done. You're done. So, yeah, it was a divorce hearing. So that sucks, because if it was property, if it's kiddos, you can always go in and file a modification later on, right? Depending on the situation. But if it was property, you're toast, you're done if it's been more than 30 days. So, James, I see your wheels are spinning here. What's going on? What are you thinking?
I have to do more research, because I remember post-dissolution, right? But that doesn't work that's what I'm thinking. That's where my head's going. Post-dissolution, hey, look, this thing wasn't considered or should have been considered. That's where my head went. But I gotta research a little bit more.
So I think what you're talking about, and I think that's what you're thinking is, let's say hypothetically speaking that he did this divorce decree, but in the divorce decree, he didn't award the house. He just left that information out. Then what you can do, if you're not able, if the time has passed for that default judgment to be set aside, or for that new trial to be filed, then what you can do is you can say, all right, judge, I want to file a petition for post-dissolution division of the estate.
Let's go. Yeah. Oh, that's what I meant. That's what I was saying the whole time. Is what I was saying.
I got you. And so basically you just say, in this divorce decree, they divided all this other stuff, but they forgot this one thing. They forgot the house. And so now I want to go in and divide that. And the judge will say, yeah, that was part of the community, so let's divide it. So you're right, James, that's a workaround depending on what the decree says, right? That one that I was telling y'all about that we did get set aside, where the lady didn't file the answer, it was a little like, and then again, this is why you have to hire good lawyers, because in that particular case, I was part of the elements of setting aside a default judgment is that it can't be what we call an conscious indifference. And so meaning like you can't just throw it on the counter and say, peace out, I'm not going to worry about it right now, right? And in that particular case, she did that. But what we were able to do is we looked at the petition, and in that petition, they had stated that the parties were just going to enter into an agreement as to custody. And so then when that lawyer went to court, they ended up defaulting her and getting primary and giving mom standard visitation and all this other stuff. And so we were able to kind of win on a technicality of, look, judge, the pleadings didn't match the judgment, and therefore you could not have rendered the order the way that you did. It's technically void because it was a due process violation, right? And so there's other, and like you're saying too, James, like that motion, there's ways that you can get around it, but it's expensive because we have to pull the pleadings, we have to pull the order, we have to pull the transcript. There's all sorts of stuff that we have to look at to see, you know, did they prove this up properly? Because that's another thing. If this guy took all of the estate, like 100% of the estate, and left the wife with nothing, and his lawyer didn't prove up like a fault in the breakup of the marriage, or you know, some sort of separate property claims, or some ways to establish that he actually deserved all of that, you can try to set it aside through that way too. So they're fun. I mean, they're fun. Yeah. They're frustrating because you're just like, oh my gosh, we can't do it, or there's nothing we can do to help. But if you hire a good lawyer, sometimes we can work around it. But I don't know. I can't answer the question because I don't know when the hearing was and if the order's been signed and all that other good stuff. So, all right. What's next? Let's go question 3. James, you want to read that one?
Sure. Can I represent my case in court? My court date is in 3 days, and they just want me to take some classes for mental health and anger management because they have no proof. I hit my child, but because the child said I hit him, that's why. But I would rather not take the classes. Can I go to court without a lawyer?
So did he hit the child, or he's just saying?
It says I have no proof, period. I hit my child, but because the child said I hit him, that's why.
Okay, so it's like a false allegation type thing.
Okay, but I would rather not take the classes. Hey, I feel you. Can I go to court without a lawyer? All right. Julie, what do you think?
There's Christina's eyes for me on that one. Let's give that away. The noise James made is for a good reason. The answer is technically yes, you can, but no, you should not ever. An injury to a child is a felony 3 offense in the state of Texas. It is very serious. It can have consequences for the absolute rest of your life. It's worth it to get an attorney. If you can't afford an attorney, you can try to get a court-appointed one. But there's absolutely no situation with this much on the line that you should ever go by yourself.
So I don't know that, is this a criminal? I feel like it's a civil case, right? So I don't think he'd get a court-appointed attorney. Or is it, I don't know, I guess it's criminal?
I took it as criminal as injury to a child if they're just saying anger management classes to get rid of everything. That's how I read it. I don't want to.
Are you thinking CPS?
Are you thinking CPS or tort?
CPS, or like some sort of a modification, you know, where they're trying to request that he take these classes because, you know, maybe.
It could
so,
be.
If it was a criminal case, then yes, absolutely court appointed. If it's a CPS case, also you can request a court appointed attorney. If it's a modification, a custody dispute or whatever, you can represent yourself. And I guess let's take those in turn. If it's a modification, Julie, what do you think about him going without a lawyer?
I mean, you can list any one of those cases and I'd say don't go without a lawyer.
Yeah, excellent.
There's no situation where this is ever a good thing or a good allegation, whether it's CPS, whether it's criminal, whether it's modification, whether it's any of it. There's no good situation to go without a lawyer for this.
So I'm trying to think because when you show up to court and you represent yourself, you have the opportunity to ask all of the witnesses questions. So you can cross-examine them the same way that a lawyer would cross-examine them. that is not your testimony, and the questions can't be used against you, right? Right.
But
Okay.
you're also held to the same burden and standard as a lawyer, as far as all the rules of the court go.
Right. And so what that means is like rules of evidence, rules of procedure, objections, legal arguments, all that crap, you're going to have to know it to represent yourself, because the court can't help you out. The way that the judges typically do it when you represent yourself is you get to ask questions if you want to. And I would say 95% of pro se litigants shut down and say, I don't have questions, because it's intimidating and it's scary and you don't know what the hell you're doing. And so most people shut down. I will say that I have had some pro ses that like gave me a run for my money. I was like, holy crap, like what is this? Like, why didn't you go to law school? So I have had that happen, but most of the time people they just don't know what to do. Now, the trick is on this particular case is that the dad would have, and I don't know that this is a dad, I'm just going to say it's a mom, because Floyd always gets mad at me because I say dad. So in this particular case, mom gets to take the stand. And in all cases, if you're a pro se litigant, you get to take the stand and the judge will tell you, give me a narrative response, or tell me your testimony. You get to just narrate it. You tell your story. Once you're on that stand and you're telling your story, you're under oath. And so anything you say during that narrative would be considered what we call a judicial admission, right? And so if you admit during that narrative that, yes, I did hit my kiddo, and this is why I hit my kiddo, then potentially the other side, the CPS, the attorney for the father, the court, they can pull that transcript, and then that could be submitted to the state for criminal prosecution, because it's a judicial admission. And so I would say typically one of two things happens when I have a case like this. Either my client is 100% adamant that it did not happen, no way, no how, it's completely fabricated. And in that particular situation, we prepare and they tell their story, because I feel like you have to. If you are 100% completely innocent, you have to tell your story, but you better be ready for that cross-examination, because they're going to come for you, right? If there's any sort of a potential that maybe my client's not the brightest Crayola in the box, or maybe there's some little thing that they should not have done, then we don't testify, because we don't want them to risk potential criminal prosecution. And it's a case-by-case basis. And at the end of the day, it's the client's decision if they want to testify or not. And so we tell them, and then they make the decision. But I'm 100% with you, Julie. Like, don't represent yourself. Even if you're not dealing with this crap, like, just don't. If you can avoid it.
Yeah.
And I will say I've been the prosecutor sitting in the back of a family courtroom taking notes, and literally I went back up and said, we're going to pull this transcript and I'm good. Thanks. No, you don't have a plea deal anymore.
Exactly. Yeah, that's.
Can we talk about how the kid basically put a case on their own parent?
Lord.
Because I mean, it's a new day. It's a new day.
There, I don't think we should be talking about that.
Okay. All right. I'm just saying it's a new day when children can just tap somebody on the shoulder. Hey, mom hit me, dad hit me, and then poof.
But listen, so the reason why I'm doing my eye rolling thing is because right now, and here in the recent past, like I have had these cases of parental alienation and false allegations. And unfortunately, those are typically perpetuated by mothers against fathers. And they are horrific allegations, sexual abuse allegations, physical abuse allegations. A lot of times they're going to be tied with a criminal investigation. And to me, like those types of cases and the people that are capable of making those allegations, they're just the worst of the worst that we can ever have to go up against or deal with, because it goes down to a he said, she said, right? Number one, like, oh, so in a lot of the cases we have, it's a situation where mom calls CPS and says, well, the kiddo just told me that daddy touched their private areas. And so CPS has to go, they do their investigation. A lot of times they call the police go out and do an investigation. They take that kiddo to do a forensic examination, which, I mean, I don't care how old the kiddo is. They know that this is weird, right? They're in a little room, they're talking to a stranger about their private areas. And it's just not something that I would want my children to ever have to go through, but that's what these kiddos go through. I've had some kiddos, 5 and 6 year old little girls, where the mother takes them to get SANE exams, or a SANE, excuse me. And it's all this trauma that you're perpetuating in this kiddo because you're trying to gain some sort of strategic advantage by making false allegations. So it's not even necessarily the kiddo that may have said this, and I guess maybe in this case he did, but a lot of times it's the mother or father putting it back in the kids' heads, and it's a lot. It is a lot, and it's unhealthy for the kiddos. And I will tell you that I have won cases when mothers do that, and like I said, my cases have just been the moms where I'm experiencing this. One custody of kiddos because that's what the moms do, and limit visitation for the mothers because they do this. Just don't. I don't know how else to say it. If there is legitimately an issue or a safety concern with this kid, address it, but don't make things up, because judges will be so quick to snatch those kids from you, because it's a mental health issue. It's a emotional welfare issue, right? And so I don't know, these cases piss me off. I don't know if y'all know this.
Yeah.
I may know.
Rightfully so.
Yeah. So, and we've had cases too where kiddos have said, yeah, my dad my dad did this to me, or my mom did that to me. And then, they're teenagers most of the time. And then a few weeks later they recant, and they just don't understand the consequences of the things that they're saying. So I don't know. And it's sad because it has big consequences for the parents in those cases, and lots of money spent defending them. So anyway, but
just keep it real. Yeah, keep it real. No need to lie. Just, did it happen? Didn't it?
Right. All right. What's the next question? Let's go with number 9. Oh, that's funny. James, go ahead and read.
Okay. Oh, this is funny. All right. What is the best state for a woman to get a divorce if she has significant separate assets and wants to protect them? I have significantly more assets than my husband. She's bragging. He is not entitled to the real estate rentals, and I'm concerned that Texas will still consider them to be community property. I also have significant growth in the managed account that Texas will consider community property. I want to move to a better state for classifying / protecting separate property before filing for divorce.
Damn.
Yeah. CJ / Julie, what do y'all think?
I don't know. Texas is the best state in the world.
Oh, that's right.
I mean, do y'all know of any other separate property laws in other states? Because I don't. I know Texas law. That's all I know.
No.
I think we have good separate property laws in Texas.
Right. And she's describing them as separate property. So I feel like she has an understanding of what separate property is. And if they are indeed separate property, and you can trace them back, or you can go back to when it was purchased, then you should be all right.
Yeah. So I guess let's kind of talk about separate property, community property. Who wants to explain that difference?
Right.
Go rock.
Right. I was like, thanks, James. Appreciate you on that.
Y'all want me to explain it?
Separate property is separate. It's something that if you have it before the marriage, right, before you become a community, then it's separate property. It can also be gifts or inheritance or things like that. But if it is, then there's definitely ways to keep it maintained as separate property and not have it be considered as part of the community estate. And tag CJ.
And what?
And tag CJ.
And community property is anything that is acquired during the marriage. And I'll tell you that at the time of divorce, everything that you all own is going to be presumed as community property. Okay. And so what James was talking about is this concept called tracing. Okay. And so basically what that means is if you are alleging that the property that you have right now at the time of divorce was yours before you got married, you have to prove it, right? And typically what we're looking at is, contracts, we're looking at the initial payments that were submitted, we're looking at what else? Testimony, where if it was a gift, we want witnesses and or any sort of evidence that it was potentially a gift to you during the marriage. If it was an inheritance, we want to see the will or the letters of administration that gave you these assets. So we have to walk in, and the standard is clear and convincing evidence to prove to this court that, hey, this is yours and it's your separate property 100%, right? So depending on the case, it can get super complicated because a lot of times what you'll have is what we call mutation. And so you have this asset that you acquired prior to marriage. Let's say you had a house and you sold that house, and then you turned around during the marriage and you bought another house, and then you sold that house and you turned around and you bought another house. So we start having all of these different transactions that we're going to have to prove by clear and convincing evidence that this house that's currently in existence is only because we have this separate property that we now use to purchase this house, right? So it can be difficult. It can be expensive. It's a pain in the neck, especially when you have, some of these divorces, they're, 20, 25-year marriages, and having to go back and prove all that stuff. It's cumbersome. And sometimes you can't get the documents, which is kind of crappy. But like James said, if you can trace it, you're going to be fine. The account, so she says significant growth in the managed account that Texas will consider community property. So I am presuming that account is tied to the rentals. Is that what y'all are thinking?
I would think, yeah.
So yeah, any income from separate property is going to be community property. And so that account will be split in Texas. And so I would Google the best separate property state, and then go there.
Maybe California. I don't know. This isn't legal advice.
No, yeah,
Never California.
Right, for sure not California. Don't they have like horrible, like worse laws than we do? Or no? Is that just, yeah. I feel like they I don't feel like they're very favorable when it comes to property. What I would also say, and I don't know, I hate this. I hate it, but prenuptial agreements are lovely.
Mm-hmm. That was my first thought, was get a prenup.
I mean, listen, when I got married, neither one of us had crap. And so it was like, listen, we're building this together. But James.
I'm here. I'm with you.
I feel like you're not a fan of the prenup. Is that what's happening there? You're still young and in love. You're in the honeymoon season.
Yeah. I mean, yeah.
What's the song? We want prenup.
Exactly. Go figure. Yeah.
Oh, but it's funny. We actually had a conversation about this recently. Mm-hmm. And for certain situations, like say I'm, you aren't speaking to James Palin, you're speaking to James Rockefeller, something like that. Where my family is like, hey, well, look, you have certain things that you're gonna have to do on our behalf because of what we've built. We know you're in love. You know, if she wants you for you, she's gonna be all right because she's gonna be down for protecting the family. That argument, I'm still a little hurt in here, but I understand it. But apart from that, I'm like, come on, really? It's one foot in, 1 foot out, kind of.
I'm a fan of the prenup.
Julie's like,
balling though, but Julie's balling. You know.
I'm a fan for the prenup.
I mean, so I think that there is definitely certain situations where it makes sense. I mean, so hypothetically speaking, you know, wife is a real estate, you know, owns all this real estate, and she's built her empire, and she, you know, goes on vacation to, I don't know, the Caribbean and meets her some young guy, and she's older and she wants to marry him. Hell yeah, we're doing a prenup. Now, we're going to take care of it. But, and then also, you know, I feel like this normally comes up, the prenups that we've done, it's typically second marriages, right? And these people have kind of learned their lesson from their first divorce, and they're not trying to go through that again and lose half of everything. And a lot of times it's younger individuals that they're wanting to get married to. And, you know, and a lot of them that we do, they're the clients that we represented in the first divorce, and they come back and they say, hey, Christina, you know, this is what's going on. What should I do? And I'm like, we're doing a prenup. There's this is happening.
Okay. I get it.
But when you're young, and like I said, James, like whenever, you know, we got married, that like, I think if Brian would have asked me, and at the time we got married, he was making like way more money than what I was making. I was fresh out of law school. If he had asked me for a prenup, I think it would have been like, I'm out. Like,
yeah.
Right? Not Julie.
Hey, not Julie.
I'm like, yeah, I'm drafting it. What's going on?
That's not here. Initial here.
Exactly. But I would not, because I agree with you. It's kind of this, how are we supposed to build our lives together when there's clearly not like trust, right? That's a trust thing. Yeah. So whenever we got married, I, for whatever reason, just thought that we should maintain separate bank accounts. I was like, you have your money off my money, like it'll be fine. And Brian was like, nope, our money is our money. Put your stuff in this bank account. And that's what we did. And
Brian, shout out to Brian. He's a real one.
I don't know why. But what is funny is not every time, but a lot of the times when we're doing these, you know, initial client meetings or consultations, and I start asking about bank accounts, the couples that say, oh no, she has her money in her own account, I don't know what she has, and I have my money in my own account. A lot of the divorces, and y'all pay attention when y'all are doing these consults, a lot of them, that's the way they handle their business, is it's just completely separate. And I kind of feel it's just an indicator of lack of trust and probably why they're going what they're going through. So yeah, you got to share. It's all in. But as far as this question is concerned, I have no idea where the hell to go. What I would do and what I have done when I have people that have these concerns is we'll have them hire us, and before they decide to make a move, we do like a legal assessment on this is probably what's going to happen, and so this is what I think that you need to do, right? And we try to find the cleanest way to navigate through that before you make a move. And I'll tell you that is one of the biggest mistakes that I see younger attorneys doing, and even like older attorneys that just don't have the experience, or I don't know, maybe they just don't care. I don't know what it is. But a lot of times what will happen is people like this will come into the office and then they'll say, all right, yeah, we're just going to file the petition for divorce and we'll kind of see how things shake out in the end, right? Well, then by the time everything starts landing, this person's completely screwed, right? And so at our firm, when we have complex cases, we have what we call case strategy meetings where we're talking about, okay, if we make this move, then this is going to happen. If we make that move, then this other thing's going to happen. And so how do we mitigate the risk, right? Like what do we do to protect this person? And sometimes it's like, we can't make a move right now, right? And other times it's like, well, let's make sure that this thing happens. And now we're going to be ready to make a move. So be mindful of who you're hiring is all I'm saying, and make sure they're not just filing just to go and get their billable hours and make that money and get you on the hook, because that's not always going to be in your best interest. And in this lady's case, she needs somebody who's going to sit her down and say, all right, this is how things are going to go down, because she's probably going to lose some money.
Yeah, that's tough.
Oh, we have a question. I don't know that we can answer this question. I'm going to hold off on that real quick. Let's go to question number 5. Julie, you want to read that while I look something up real quick?
Absolutely. I have my kids for the month of June, but my ex has put them in camp without consulting me. What can I do? I get them for the month of June. He gets the girls for July. I have a vacation plan, and he put them in summer camp without asking me.
Okay. Well, you have a couple options. You could let them go to summer camp and, do all that, or you could abide by the order, which is what I would recommend, particularly since you've already made plans. That's on him. If he's wasted his money, hopefully it's refundable, but your order is clear. You have a period of possession in June, and this camp is going to run into that. He should have consulted you. He should have got permission to do this camp. So whatever camp it is, math camp, space camp, it's going to have to wait if you say so. And that's, according to your order. I think that's relatively straightforward.
And so what if the camp is during his own time?
Well, if it's during his time, then, you're free to do with your time whatever you'd like to. Take him to, Amsterdam, take him to Florida. That's a big
We're doing some high rolling over here, aren't we?
I'm just trying to go from extreme to extreme.
He's like, take him on a world tour.
Right. I say all that to say he can do whatever he wants, right? Take him to Cleveland, Rock and Roll Hall of Fame. Take him to the George Bush Library, Dallas, Texas. You know what I mean? There's all sorts of places you can take him without her say so. But if it's going to be in her time, you got to at least make the request, right? So what I think is happening here is a strong arm move. Well, hey, I already paid this money. They really love this camp. You're going to break the kids' hearts if you tell them they can't go, right? That's sort of manipulation. But at the end of the day, it's not about her saying no. It's about you being responsible, reading your order and abiding by the order, just like she has to on your month. You know what I mean? Right.
I 100% agree with that. And I have that. Have y'all had that happen in a lot of y'all's cases? And I hate that. And what I say, or what I try to encourage my clients to do, is say, all right, if he scheduled this camp, let's get him in the camp. And let's see if we can switch weeks, right? Because at the end of the day, what mostly matters is what's best for the kids, right? And if this is something that's going to be beneficial to them, then let them go. But if the other side's not cooperating and they're just kind of being difficult and maybe doing this, like you're saying, James, to be manipulative, then dad's just, or dad, why do I always blame dad? Mom's going to be out of money here.
Well, this one was dad. So I mean,
was it dad? Okay. Well, and it's funny because I think if I had to sit down and look at my numbers, I mostly represent dads. But yeah, I don't know why I keep saying that. And don't plan stuff. If it's not your time, don't plan stuff. You're going to lose the money. It's dumb. All right, so the question on Facebook: can I change my son's name if I have sole custody? This is a request from my son after extensive counseling. Father has been non-existent in our son's life, but 3 times in 6 years. My relationship with father's mother is great. He's always had a way to find our son, even had his number, and chose to never reach out. At this point, our son wants nothing to do with him and wants to be adopted by stepdad. Stepdad has been in his life for 6 years. So Trina, I would say that this is a kind of a complicated question to answer. I guess short answer is no, you cannot change his name. Let me rephrase. You can request that his name be changed, but it's unlikely that the judge would do it if dad is still going to maintain his parental rights, right? So typically, and especially if you're saying kiddo wants to be adopted by stepdad, then a lot of times what you're going to have to do is you're going to have to do a termination adoption, right? So terminations are very, very difficult to come by if they're what we call involuntary. And basically what that means is you have to prove like some sort of an abandonment issue, an endangerment issue. There's like 17 different ways that you can get an involuntary termination. Okay. But someone just not being an active participant in a kiddo's life, a lot of judges are probably going to be a little bit hesitant to terminate because it's kind of a death penalty solution, right? And so typically what we try to do in cases like this is we try to do what we call voluntary terminations, where dad signs what we call an affidavit of voluntary relinquishment, basically saying, hey, I am well, dad was arrested for human trafficking, so maybe termination would be easier. Maybe, but there's still some issues with that. And so what you're going to want to do is you're going to want to consult with an attorney, and they're going to have to look into that particular situation. I don't know that would be enough for an involuntary termination. Okay. Because there has to be an endangerment, like the offense typically has to involve the kiddo or put the kiddo in some sort of danger to be able to get the termination based on that criminal offense. So I think it's potentially a little bit complicated. I would say a voluntary termination would hopefully be the best bet. Typically what we do in those cases is we'll, attempt to restrict dad's access, and maybe increase his support, maybe try to hold him in contempt of court for not complying with the order. And then hopefully, potentially, dad would say, listen, I don't have time for all this. I'm not seeing this kiddo anyway. And so I just want to relinquish my rights. And so domestic violence, same issue. Even if there's a history of domestic violence, it's going to depend on that particular fact pattern, right? So what I would say is you probably need to set up a consultation, and go in and talk with an attorney about here's everything that dad did, and then my preference is always to try to get that voluntary termination if possible. Okay, once you can get that order, then you facilitate the adoption, and in the termination order, you can get the name change, right? And then in the adoption order, that's when stepdad would have all the legal rights of a parent, and then you wouldn't have to worry about dad at all. And so I know, and you're welcome, I know I'm not answering like 100% this question for you because there's so much information. Typically when we do consultations, it's an hour, sometimes an hour and a half, because I'm asking all sorts of specific information and trying to figure out a way to potentially get the goal accomplished, right? And sometimes I have to go all the way around to be able to get this name change for your son. And I do appreciate it because I've had a lot of clients that, stepdad's been the only dad that they've known, and they want to be whole and they want to be part of the family. They want to have the same last name. And so I definitely think it's something you need to look into. And hopefully we can get that done, or somebody can get that done for your son. So, but all the stuff that you're saying, there's some research to be done to potentially get that accomplished for you. So let's go. Last question. What number shall we do? Let's go.
Number 2, maybe.
Go for it.
Okay. Can my shoplifting charge be enhanced? My court date is in 3 days. No, sorry, wrong one. I got stopped for shoplifting. This is my 3rd misdemeanor theft, but the first 2 were over 10 years ago. Is it likely the charge will be enhanced to a felony, or will they factor in that I haven't been in any trouble for over 10 years?
I'm gonna go with Julian on this one. Tag.
Yes, it can be enhanced. The time frame unfortunately doesn't matter. It could be 10 years, could be 20 years ago, it could still be enhanced. Whether it will be or not, that's up to the individual prosecutor and county that you're in to make that charging decision on what they'll do with it. I will say most prosecutors in punishment will consider that it's been over 10 years, but the fact that it's been 10 years and then you did it again could be an issue if in fact you did do it again.
So is there anything that he can do, or is he just up to the discretion of the prosecutor?
It's up to the discretion of the prosecutor as far as whether it can be or not. If there's something he can do, it's show how good you are in the community and try to front load a lot of the stuff to make it where the prosecutor doesn't feel that you are a danger to the community and that you won't do it again. That can be character letters, reference letters, things like that. It's hard without getting into the facts of the case to know exactly what this was or what this is. It is very fact specific on which way you would go and what you would need to be able to show. But legally, if they want to, they're going to be able to.
Well, and so, a lot of times in the criminal cases that we handle, that's what we do, right? During the negotiation process is we try to, I guess, incentivize the prosecutor to not do certain things, right? By potentially showing weaknesses in their case, potentially showing, hey, this person just made a mistake and here's all this wonderful stuff about him. Or maybe this person was in a particular predicament that they just made a really, really bad choice and now we're here, right? And so we've done that. We've done, packets of information for prosecutors to say, hey, I understand that that technically he's good for it, but maybe this is why you should give him a little bit of a break. And depending on the prosecutor, some of them can be reasonable and good and do things like that. And then others just say, no, I'm not going to do it. And then you're stuck in a situation where you get enhanced and it sucks.
Right. And shoplifting is just difficult in general because there's such a fine line between taking a sample and stealing. You know what I mean?
I would be more specific. What they will look at is stuff like that is, was it diapers for your kid? Was it something you need? Or was it an iPod that you needed for fun? I mean, that kind of stuff matters. Do people use iPods anymore? I don't know, but stuff for things like that.
But I mean, you take the iPod, you listen to it for a little while, you put it back. Is that shoplifting? Is that a sample? Who's to say?
Yeah. All right, guys, we're out of time. It's already freaking 12:59. We're gonna get in trouble. So with that being said, like I stated at the beginning, I think I may have said it in the middle. I don't know, but if I didn't, I'm going to say it now. This is not to be construed as legal advice. Okay. You have to please go and see a lawyer if you have any sort of situation similar to this, because as we saw with Trina here, there's all sorts of different little things that could potentially change how an attorney should handle a case. Okay. And so go find yourself a good lawyer, tell them your particular situation, and then follow their advice. Okay. My hope is, and the reason why we started doing this many moons ago is because there's a lot of information that maybe some lawyers don't know. And obviously most of the lay people don't know. And so we want to give you little hints and little clues and little tips that potentially can help you on your journey, because a lot of times these are very, very difficult journeys. And so we want to give you little tips to help you. But we can't give you legal advice because we just don't know what's happening in your life. So find a good lawyer, go and visit with them. And as Keon always makes me say, follow us on all social media platforms, and we look forward to seeing you guys again next week. So y'all have a good weekend. Bye, guys.